everyone. I hope everyone can see me and hear me as we head into the next session, which is titled Transnational Governance Gaps in the Extractive Corporate Supply Chains, with a particular focus on the Total Energies case. To briefly introduce myself, my name is Sikho Luthango. I am a program manager at the Rosa Luxemburg Stiftung, and I lead our work of ensuring accountability across the supply chain in the Southern African office, which is our main program objective. And I will be moderating this next session.
Eu serei a moderadora da próxima sessão.
Context of the COP28 climate change debate about the need to phase down or out fossil fuel projects in respecting common but differentiated roles of states in the energy transition. And there are several issues that come to play in this regard. The discussion spotlights, one, the role of oil and gas in the energy transition, and the role of trade agreements that continue to be a barrier for the transition, putting many states at risk for international dispute mechanism arbitration. Finally, human rights issues are also a central part of the energy transition, where the displacement of communities tends to take the center stage, especially in the global south. And the two cases we will discuss today will illustrate this. So this then brings into question the governance of natural resource governance across the supply chain in the context of an energy transition to ensure that it is just. Today, we'll focus particularly on the Cabo Delgado province in Mozambique, which has become known for its displacement of farmers and fishing on traditional land, armed conflict, and economic inequality caused by the development, which is related to the pending and contested gas boom. The investment is expected to be the largest of its kind in Africa, basically putting into the question of development as well within the energy transition and industrialization. At the same time, in Uganda and Tanzania, displacing over 100,000 people, Total is developing the Tilenga oil extraction project, which is associated with the East African crude oil pipeline jointly with USD 10 billion, violating the land rights of the displaced, including allegations of unfair and over-delayed compensation. Human rights due diligence processes have become central since the implementation of the United Nations Guiding Principles on Business and Human Rights. However, as most states adopt binding human rights due diligence legislation, there is a disconnect in how corporates implement due diligence processes and in how they communicate these processes, raising questions about a more binding international governance of one human rights due diligence process and generally natural resource governance, as it relates particularly to transnational companies. As panelists today, we are joined by Dickens Kamugish, who is the current Chief Executive Officer of the Africa Institute for Energy Governance. He is also an advocate of the High Court of Uganda, a member of the Ugandan Law Society and East African Law Society. Dickens has undertaken many professional trainings, including the access to biological resources, benefit sharing and material transfer agreements, international trade policy, biosafety mechanisms, intellectual property law, and health in Africa. He has also trained on oil governance from Petred, Norway, and Environmental Law Alliance Worldwide, USA. Since 2007, Dickens has continued to mobilize and empower local communities across Uganda to fight against the environmental, social, and economic impacts of oil. Currently, Dickens is part of a legal team handling 5 oil cases in the High Court and Court of Appeal of Uganda, 1 case at the East African Court of Justice, and another case against Total Energies in France. All the above cases are aimed at stopping the danger of oil exploration across the supply chain, including where Total Energies is headquartered in France. Our next panelist is Kete Fumo, who has a master's degree in human settlements and environment from the Pontifical Catholic University of Chile. She's an activist and employee of Justiça Ambiental since 2008 in the Extractivism, Human Rights, and Corporate Crimes program. Our third panelist is Juliette Renaud, who is a senior campaign on corporate regulation for Friends of the Earth France. Since 2008, she has been working with communities affected by mining and oil companies around the world, and more particularly in Argentina, where she lived for several years and worked as an advisor to Nobel Peace Prize Adolfo Perez Esquivel. Within Friends of the Earth France, she's in charge of the advocacy and campaign activities on corporate impunity related to human rights and environmental violations. As such, she was in the core group of organizations that fought for the adoption of the French law on duty of vigilance. She also coordinates the French Coalition for the UN Binding Treaty and is the regional coordinator for Europe of the Economic Justice Program at Friends of the Earth International. And finally, we have Erika Mendes, who is a social and environmental activist and member of Justiça in Bashir, excuse the pronunciation, a Mozambican civil society organization working on environmental, social, climate, and gender justice, where she coordinates the corporate impunity and human rights area and works closely with communities affected by extractivism and mega projects. She has been working on the process of the negotiations for a United Nations binding treaty on transnational cooperation and human rights for the past 7 years, and is also the regional coordinator for Africa of the Economic Justice Program at Friends of the Earth International. I'd just like to have a look if we have all our panelists, because the first to go ahead is Dickens. Dickens, are you here? While we wait for Dickens, maybe we can continue with Kete Fumo, who'll be giving us more of a background about the Mozambican situation. So translation is available for those who want to make use of translation in Portuguese and French. And Kete, have you joined us? Could you just please welcome Kete? Kete, can you please describe the conflict situation in the Cabo Delgado province in Mozambique? Basically, the entry of Total Energies, the pause and re-entry into the province.
Hello, good morning.
Morning,
Good morning, everyone. I don't know if you can hear me.
Yes, we can hear you, Kete.
Thank you. First of all, I want to thank you to address this invitation for us as Justiça Ambiental to be participating in this event. And regarding to the question addressed to me, I would like to, first of all, talked about how the situation, conflict of Cabo Delgado started in October of 2017. And when the conflict started, we first had the beginning of the project. The project started almost in 2012 or 2010 and 12, but in 2017 we started to have the conflict situation in Cabo Delgado, and in all this time from the beginning until 2019, the project belongs to the American company Anadarko, who sold these shareholders to Total.
Eles venderam as suas ações para Total.
2019, and when they started to work in Cabo Delgado, the conflict had already 2 years, and we had more than 100 people already died due to the insurgency in Cabo Delgado. And in 2020, there was an escalation of the conflict where the insurgents went from the violent and rapid invasions, attacks, looting, extreme violence, followed by escape into the woods to invading and occupying districts for long periods of time. They started to increase and even to connect to the other international terrorist groups, but also with a different way of action, because they never had a clear agenda, but always regarding the social problems living in Cabo Delgado that have been exacerbated by the start of the project. The insurgency started to demonstrating into 2020 organizational and confrontational capacity with the defense and security forces of Mozambique. And in 2021, after the interruption of the project due to the COVID-19 pandemic, the resume of the project were conditioned due to the attack by the insurgents on the town on the village of Palma, because the project has been interrupted due to the COVID-19. But when they wanted to resume, or they announced the resume of the project, the insurgency started to escalate, including getting in Palma village, where the protection from our national defense of Mozambique were really strong. So Total acquired an adequate participation, as I already mentioned, in 2019, and the president of Total states that the project has a minimal risk, since 19% of the productions has already been sold of the natural gas to Europe and Asia. So this declaration demonstrating that the project has a strong economic focus, which ignores the reality surrounding the projects. So this attack forced the project to lift a force majeure, and which culminates in the long break of 2 years. So recently, in this year of 2022, Total and the government announced the resumption of the project under a specific conditions declared by Total, which are around of security issues. So the conditions that Total asked the government to guarantee is that the area has a security situation, and to preserve human rights, and also to guarantee that the project cost after the interruption of more than 2 years will be cutted, in which are the projections that the government of Mozambique has, meaning that all the projections that our government probably made will be affected by this longer situation of conflict, and all this situation of communities being affected by this project, with the longer process of resettlement, which also started in 2019, but which only closed this year due to all these interruptions, COVID-19, and also the conflict in Cabo Delgado. Now we're still living in the situation of force majeure. The force majeure is still on the ground, but we can see that Total is still working on the area. The activities have been implemented, but officially the force majeure is still working. Thank you.
Thank you, Kete, for that background. I understand that an independent uprights expert report was conducted to particularly review the human rights due diligence process of the Mozambique liquefied natural gas project, which is operated by Total Energies. Could you provide more information, Kete, on these findings, especially in terms of the disconnect between what the project has been communicating on its website and in corporate communications on the human rights due diligence process and how it was conducted, and the human rights situation on the ground?
Well, it could be seen because all the actions that Total are taking on the ground are not really connected with what are the expectations or the real necessities of the communities. Since the project started from Anadarko, since now from Total, you can see this disconnection, because all the concerns and the questions that communities have never been well addressed. All the activities that are on the ground are most focused on what are the goals that the project has. specifically to these reports from Uprights. One of the findings is, as I already said, this disconnect between this project and the commitment to respect human rights in all its operations. It can be seen by our work on the ground, which in 2018 and also in 2019, we noticed that in Palma, the level, the number of military positions surrounding the area of the project were really high, leaving the communities without any specific protection, while we already know about the attacks surrounding another districts of the north of Cabo Delgado. The insurgency started in Mocimboa da Praia, which is a district really close to Palma, 1 hour of distance, but the high level of protection in Palma district led another district surrounding the area without a specific protection, which made that most of the attacks occurred in those districts, as Macomia, Mudumbi, even in Mocimboa da Praia, Macomia, Mudumbi, and also in Mueda. The project failed to provide security for community, and they also it also can be seen by reports released by Alex Perry, showing that the project closed the gates on the day 24th of March of 2021, when the attacks occurred to Palma. The insurgency attacks get into the village, and the specific number of deaths in that day were never been really clear. And now, after this independent investigation from these journalists, we can find out that almost 1,300 people have died. And while Total had promised that the security of communities have been guaranteed, what happened is that when people went to the campsite where Total is, the gates were closed, and the managers have left in helicopters, leaving the community abandoned. And what happened is that the Ketunda village and all areas surrounding the projects were the most secure for people to go, because the high number of militaries, which is almost 700 of military in the area, made that the area was really protected, leaving other areas and other communities and also workers from the companies subcontracted by Total that didn't have a properly protection, which shows how that the study they have to guarantee the human rights violations was not properly conducted, because it never considered that communities are part of the project of Total. Since the situation is happening in the area, are connected to the project. The other important finding in the area is concerned to disregard by human rights due diligence process of the armed conflict in Mozambique. The human rights due diligence assessment that was conducted in 2020 by a consultant contracted by Total and the following action plan failed to properly prioritize consider the armed conflict and the properly conduct with a conflict-sensitive approach. Which is really curious, because, as I already mentioned, they are on the ground since 2019, and they already know of the situation of the conflict, and also knowing about the daily escalations of increasing the number of people displaced and the numbers of deaths in almost all districts surrounding the area. But a proper due diligence of human rights never have been really done, or if it had been done, it never have been communicated to the workers in the area, since as they closed the gates and left the communities abandoned. And also it also shows, this report also shows that the Total Energies, they never had a clear strategy in advance to address the potential human rights impacts that might result from termination or suspension of activities. They were not prepared to address the protection of communities affected by the activities due to a suspension of its activities when they declared the force majeure, and did not have any clear strategy showing how it would continue the implementation of the resettlement plan and the protection of the community who were resettled or waiting for resettlement to Kutunda village. That's to make the communities living in an uncertain for all these 2 years. Just for you to have an example, a clear example is the community of Kitupu, the major village affected by the project with the higher number of families to be resettled. Their resettlement process being interrupted in the middle, while that other half of families had to remain in the village for more than 2 years without any clear information regarding the resume of the process, and being exposed to human rights violations, as those families had to live inside the gate built by Total even before the start of the resettlement process. And these families have been living all these 2 years without knowing anything about their resettlement process, and also being surrounded by militaries and controlled by them. And even for us to get into the area, you had to have a permission from the Minister of Defense, and also to be revised by the militaries to enter into this gate, which is something that made the communities to lost the access to the sea, and access also to their plots of production, which we here in Mozambique, we call it mashambas, the small plots where communities produce their food. So basically, is that what I have to share about concerning this question.
Thank you, Kete, for highlighting the issues around displacement and also a failure to continue the compensation process in regard to the displacement issues. Can you just quickly highlight, Kete, also, you've mentioned already a bit there and there, but can you please quickly highlight the shortcomings, perhaps, in terms of how Total conducted its stakeholder engagement, especially as it relates to the resettlement plan? And also, I mean, we see through what happened in the Palma attack that there is a risk in the complicity in humanitarian law violations and war crimes. And so would you also say that if a gender-sensitive human rights due diligence, a conflict sensitive human rights due diligence process, and agenda, especially as it relates to security and conflict, human rights due diligence process had been undertaken, would the project had been viable at all, having considered, one, the risks in human rights violation, humanitarian law, and also the stakeholder engagement? Would or can it be considered that this project would have been viable in the end?
Not exactly, because as we already said, that the disconnection between the project and the necessities or the concerns of communities, they never go in the same way. For example, all the process of stakeholder engagement, all the public consultation process, community has been saying or presenting their concerns, or saying which way it's more easier for them to understand what is happening. All the process of public consultation have been conducted or in Portuguese, showing maps or sharing a very technical language. You can see, if you make a quick research in the Google, you can see that the Kitupu village for example, say that they don't want to leave the area because they are not understanding well what is going to happen. When the company was showing them the maps, they said, we don't understand what these maps show us. We want to go to the area. We want you to show us that your limit area is this or that, because we understand better this language when we go to the ground and we see what really happens. So even all the situation of human rights due diligence have been considered, while they never consider what are the expectations of communities, which are really different of the expectations of the project, could be good for them. Because for example, in the case of the fisher villers, they asked to be replaced in another area, while this area has a different interest for the project. So that's why it made them to go to other area. The fisher communities had asked to be reconducted to a place called Maganja, where there is much fisher, and it's more similar to the previous area where they were working, but the project just conduct them to other area in Salama, and now the fisher communities are really dependent of the schedule of the transport of the project. So which is really different of what we are used to see, how a fisherman works. You see, because now they have to depend on the transport of the total, on the time table of the transport, which is difficult for them to have fish or to still continue with this work. And even that, of course, we due to the situation that it's already there, some recommendations have been done or have been suggested to the project. Even we know that it's not, it doesn't mean that it would be something that would say that the project it's okay for the project to continue there. It means that because the situation is already there, we have to somehow address some recommendations as creating or considering the international principles, or innate resourcing of social sector and attending roots and causes of conflict, which are many. There are many studies concerning to this conflict that already show that although the project is not directly connected to the conflict, but of course all their activity exacerbate pre-existing problems in the area. So saying that even that we make our recommendation, it means that it's okay for the project to be there. It doesn't mean that it would be okay, because since they started even with an Dargon and now with Total, we still see that it is proven that the fossil fuels doesn't bring any direct benefit for the communities and especially for the environment.
Thank you, Kete. Just also to highlight in relation to the stakeholder engagement and also in relation to the human rights due diligence process, Kete, how does a gender and conflict sensitive human rights due diligence process look like? And I wanted to specifically just give us a quick highlight of how the project has been implementing women in the context of the conflict and in the context of Total Energies as well, and the project.
Well, there are a lot of cases of sexual violations, and humans have been kidnapped or forced to marry the insurgents, and some cases of disappearance of people, and also women and children. And what we notice is that even with proper communications of what is happening of the specific cases finding out on the ground, there is no a clear strategy for the company to address these questions. And also, even we know that they have a Department of Human Rights, and they are also working with the National Commission of Human Rights. But all the cases that for the specific case of Justiça Ambiental that have been addressed to the National Commission, and even also with the knowing of Total, we still don't have a solution. And even with the recommendations to create a process that could guarantee gender consideration, we cannot see the specific actions on the ground, although the communications are there, the right authorities already know the information, but the time it is taking for a resolution is still there. And we also have the psychological impact of that on the ground, because we are talking about women who have been following a process of resettlement, which especially concerning to compensations relating to money and things like that, women always have been excluded, even by the way the communities, the life of communities flows, or even of the way the project is addressing some concerns. So the time it is taken, the proper mechanism to follow, and the specific results we need after 2 years, where of the increasing of the conflict, we still don't have specific results, and we cannot see a process of monitoring of and evaluation of emotional and psychological situations of the victims. Yeah.
Thank you, Kete. And I guess the final question for now is, what has been the experience of human rights defenders, especially in light of the heavy security presence in Cabo Delgado?
It is a really difficult role to play in that area because of the high level of security, of course, and for us to see the militaries in the area with guns, walking and even participating in some meetings of the company, because the company has a guarantee that their teams, when they go to the ground, they must be followed by a military car, and all the meetings with communities, they are surrounded by militaries, which is quite intimidating for communities, and also for civil society organizations to work in this situation of high intimidations. And also sorry, I just lost my point of thinking. Yeah. But I was about to say that there is a lot of disappearance, not only of community peoples, but also by journalists. We have a case of the journalist who disappeared in April of 2020, and he sent a message just to say that I'm surrounded by militaries, and after that we don't know about him until today. There are also another 2 cases of local journalists who were sharing the situation, the reality on the ground, who disappeared. So this shows the high level of intimidations that people or the human rights defenders are not safe when they wanted to share what is happening on the ground because of this high level of intimidations, and also because of these evidences of people disappearing, and nobody has been responsible by this disappearance. Sorry, Sikho, I have a battery really
Yes.
down. My computer is about to die, and I don't
All
have
right.
electricity this morning at home.
All right. Thank you so much, Kete. I mean, I mean, I could ask you many questions. And maybe before your battery dies, would you say that Mozambican law, sufficiently protects communities as it relates to land, for example, in terms of consultation, meaningful consultation, and because many cases are now being brought to different states like France, in the case of Total Energies, do you think that there is sufficient protection in that regard for human rights within the Mozambican context?
Well, regarding to land law, there is something very interesting happening now, because our law, the previous law, land law and the policy land law that we have been really progressive, and also pointed out as one of the best in the Southern Africa area. But what is happening now is that the national policy of land have been revised already. Okay. And all the process, we have been trying to pushing and trying to ask why you are changing something that is good, because what we can see is that the law is there, the policy is there, and it's good, but the lack of implementation of this law were the bigger problem that we had. But what we see is that they are revising the law, and the revisions they are made seems to protect more the companies than the communities, unfortunately. Although we have been making recommendations, we have been making webinars, and even the stakeholder engagement process to include communities who are the principal affected by this revision, they never knew about the process. That's why the civil society in Mozambique joined and started to create a parallel process of public consultation and to include the main concerns of communities. But this is not really reflected on the revision of the policy. And now the land law is also being revised, and all the process is really made in a secret way, that even if you want to influence, even if you want to address your suggestions, it's difficult because of this, the way the things are happening. Although they announce that things are being happening, or you can participate, but at the end of the day, suddenly you see that, yeah, things are already done. Even for the policy to be approved was a surprise for us, although we have been following all the process. So the main concern for us now is to see how the new law will protect the communities, and how can we support and guarantee that the human rights to land, the right to security, food, to have a sovereignty, sovereignty, the limitations, and to access to sea, and all these processes can be guaranteed, and all the operationalizations also can be guaranteed. That's all that for us to be to do, and to trying to guarantee the human rights to the communities.
Thank you very much, Kete, for providing such an in-depth insight into what's happening in Mozambique. Thank you so much for joining us today. Later on, we'll also unpack, the relationship between the state, the host state, and the home state, which is basically Mozambique and France, and how in the case where a state is either incapable in terms of implementation of the law to protect human and environmental rights, we are seeing more cases being brought to other states that have stronger regulation in this regard. Thank you, Kete. Dickens has also joined us now. Dickens, welcome to the session. Yes, there we go. Welcome, Dickens. I guess the first question, Dickens, is also, trying to unpack, similar to what I've been doing with Kete in this interview. We have the Ugandan oil pipeline construction at the moment. Can you just elaborate on what the project is and also how it undermines or potentially undermines human rights and environmental rights, especially in the commitments that Uganda has made that are related to the United Nations Climate Convention as well?
Thank you very much, Sikho, and thank you very much all the colleagues in this meeting. Yeah, of course, as you've said, Total is the main investor in the ECO project, the East African Crude Oil Pipeline project, which is a 1,443 kilometer heated pipeline from Uganda to Tanzania at the Indian Ocean. And this project is the biggest project so far in Uganda, which they are trying to push against all the people who are saying, no, should not be allowed to go ahead. This project started in 2006 when oil was discovered in Uganda, and the reserves they want to push through the pipeline, they come from the western part of the country in one of our biggest national parks, one of our transboundary river called the River Nile, the longest river in Africa, and Lake Albert, which is shared between Uganda and DRC, Democratic Republic of Congo. And it is estimated that this project, if it goes ahead, is going to cost Uganda and Tanzania over $5.2 billion US. That is a project, it has never happened in Uganda here. But most important is the issue about human rights and climate change issues. As I said, the reserves are coming from our biggest national parks. Mm-hmm. So far, we've seen huge roads constructed in this park against our laws, where they don't even do environmental and social impact assessments. And you can understand they deliberated not to do those assessments so that people don't understand what is going on. In any case, people are not allowed to go where they are doing those oil activities and where they are passing all the feeder pipelines from the oil reserves to the pipeline where they want to construct it. So it is unfortunate that this park is being put in that danger without any assessment, without any clear mitigation plans. The Lake Albert, where some of the well pads have been constructed, we've never done any assessment to know that these are effective mitigation plans. Mm-hmm. We have cases that we filed in 2014 in the High Court of Uganda, challenging some of the mitigation plans they had proposed for human rights, for climate change issues. Up to now, the case has never been heard. So if you look at the pipeline alone, it is affecting over 100,000 people in Uganda and DRC, rather in Tanzania. And many of these people, I tell you, if you go to those people, they were stopped from using their land in 2019. Mm-hmm. By 2022, when they said they have started paying, even those who were saying this is not fair, this is not adequate compensation, they were compelled to accept. Just yesterday, but one, those who were still resisting, the government now compared them to High Court of Uganda. They filed a case against 42 of those people who were refusing that compensation. And while our constitution says you can only take someone's land after you have paid fair and adequate compensation, Now the government has used the court to make a ruling that you can deposit the money, the government can deposit the money it has proposed as compensation into court and then proceed to evict them. And then they can wait until when the court makes a ruling on the final application. But of course, what was very painful is that the case was filed on 4th of December. The communities were served on 6th of December. And then within 2 days, the court sits down and makes a ruling without giving the other people a right to file their defense. And the judge said, if you have any issues, you can now come back to court and be heard. But in a way, these are 100,000 people that are affected by the proposed East African crude oil pipeline. Even when Total says 90% have accepted compensation, I tell you, none of those people, I must say, accepted compensation from the start. But because they were stopped from using their land and their 100% survival is on land, they had no option but to accept and take whatever was given to them. And now that, as I'm telling you, because even those who have persisted and endured all the suffering to say we cannot leave our land until we get fair compensation, the government now has used its own courts to compare those people to say, now you must take it, whether you want it or not. So that's the framework, the frame that when you want to understand the human rights issues here, you can understand. Because these families, most of them, if you go to where they are now, their children are no longer in school. Most men have abandoned the women because of the challenges they are facing. So most of these families are almost collapsing. And we don't know how much. But if you look at our country, even our constitution, it is a signatory to most of these human rights and climate change conventions, and committing that you have to protect lakes, rivers, forest reserves, national wildlife, respect human rights. And unfortunately, all those are being ignored completely because of the greed to make this money they are talking about. You know, you are going to make 30, 50 billion US dollars. They never calculate at what cost. And many of the colleagues, partners, experts who have calculated that the impact these projects like ECOP are going to do here in Uganda, they are going to be like 10 times the cost of what they are talking about money. Because how much money are you going to say if you destroy a river, if you destroy a lake, if you destroy a park that can be there for millions of years, how much can you compensate? If you destroy families and destroy the future of the children, how can you say that that project is going to be useful?
Thank you, Dickens, for introducing us to the situation in Uganda. And I mean, it seems as though that there is a complicity from the government, especially as it relates to fair trials, as you've already mentioned. So would you say that, or rather, would you just give us an insight in terms of then the cases that have been brought outside of the country, the regional cases and the international cases that have been brought to France? Can you give us an insight into at least the possibility in terms of accessing remedy in these regional courts and maybe even in France? Are communities able to achieve recourse in this context?
Yes, thank you very much. Of course, I mentioned like one case in Uganda, but we have 7 cases. And our laws somehow provide that you can only sue the government of Uganda and not the companies, especially relating to human rights and environmental rights. Even if we were to sue the companies, we've been even discussing it as lawyers. Which court in Uganda is going to determine the case where Total is involved? Most of us have no capacity to hire the best lawyers even here in Uganda. And so those are some of the challenges when we are planning to go to court. we take it into account. But we also take it into account that even before you talk about a good lawyer, the courts are being politically pressured not to fix these cases in Uganda. And that's why we said, let's work with partners to file cases. One in France against Total, hoping that the French courts are independent. And then another one at the East African Court of Justice in Arusha, Tanzania. The one in France, I know colleagues like Juliette will be discussing, but we had thought and we presented evidence of how communities were suffering injustice. We presented evidence about environmental injustice, and we had hoped that the case would go on its merits and be evaluated and determined. And unfortunately, the case that was filed in 2019, by 2022, many things had passed. And of course, the challenge was that this was a new law, the new French law on duty of vigilance. And so this was the first case under that law. We didn't know that this case would take long like this. And so the case was dismissed on procedural grounds. We never got an opportunity to see how the court handled the evidence that we had presented. And this is why, together with partners from France, we said, let's file now a new case, to make sure that at least finally, maybe the court can evaluate the evidence that is on record. The case is still in its infancy, so we cannot even say whether it is going to help us or not help us. But in our view, we've presented the evidence that you would consider credible evidence, and we are very committed and determined that we can push this case until its end, and hopefully maybe we can get a decision. And we don't care whether a decision is against us or it is in our favor, as long as the evidence has been evaluated and the court independently makes a decision. It is still a good decision because it can help us on how to move afterwards. So we are still in the French court, and we haven't known what is likely to happen, whether again we'll get it will be unfortunate for them to again dismiss it on procedural grounds, because you can never know. And you don't know whether the court is also influenced or not, because sometimes, we spent like 2 years after filing on the issues of whether it should be had in a commercial court or a civil court. So I think the court, the law does not clearly define where cases brought under that law should be defined. Is it in commercial or civil court? But we are happy that finally we got a decision that the civil court could also hear that case. So the second case was filed in the East African Court of Justice, challenging the environmental and human rights impacts associated with the ECO project. And unfortunately, again, just on 29th of November, this last month, the court also dismissed that case on procedural grounds, saying that we had filed a case out of time. And the issue was which date are we talking about? Because all the agreements, 5 agreements signed between the companies and the government have never been disclosed. So for us, we filed the case based on the date that we knew, and the law said the time when it comes to our knowledge, and that's what, but the court said, no, the governments are telling us they signed on this date, and you filed after 2 months, so your case is time barred. So in a way, there are real challenges, I think, really fighting against these companies. And the challenge, especially for the cases in Uganda, they are at East African Court of Justice. The companies like Total are too smart. They don't go there openly. They go behind the government. Government, you go to court and get a court ruling. Government, you go and arrest these NGOs that are causing trouble, so that you create fear. among the public that those who are resisting, they know they are going to be attacked. But the biggest beneficiary is Total, because it is the one in the field for the job. So we know for sure that whatever government is doing, Total is behind them and they are supporting them, and they are the ones benefiting from these injustices.
Thank you very much, Dickens, for highlighting the available mechanisms for recourse in the region, and also in the home state of the company, which is France. I'd like you to also elaborate, Dickens, on the role of other companies from different states, and as it relates to suppliers, because as I understand, there's a Chinese company involved in the construction of the EACOP pipeline. So how are the subcontractors or suppliers possibly complicit in supply chain human and environmental rights violations? And in the case of China, is there any recourse available, as in the case of France, within the duty of vigilance law?
Yeah, thanks very much. Because like the biggest oil companies that are in Uganda right now is Total Energies and the Chinese National Offshore Oil Company, or CNOOC. But these companies are not the only ones here. There are around 11 companies from China right now, which are involved in the EACOP, the Tirenga, and the Kingfisher oil projects. And the unfortunate thing is that even where we have a constitution providing for access to information, we have the Access to Information Act, we try our best to access information regarding some of these contracts on what has been agreed between the Chinese main companies and the subcontractors. You never get this information. But I think on the question of how we engage with the Chinese companies, we must say, compared to Total Energies, at least Total Energies is willing to engage. Sometimes they organize meetings with CSOs, even when they dictate whatever is discussed. At least there is some level of engagement. For the Chinese companies, I tell you, we never get them, we never see them. And every time you want to write, even these companies which are based in Uganda, and we know they have people who speak English, they insist that every document that you write must be translated into Chinese. And here we don't have capacity to really translate documents into Chinese. So it is always very, very difficult for us to engage. But I'm happy to inform you that we are working with many international organizations like BankTrack, like 350.org, which have people who speak Chinese, which have people who know how to engage Chinese entities, government, and companies. And we've improved in the way we engage with the Chinese companies. So these days, at least, there are many areas where we are engaging with the Chinese, but it is still very, very difficult. Secondly, in terms of like knowing the policies of the Chinese companies on human rights, on environment, we never get to see these policies of these companies. So sometimes when you are trying to engage, you don't know what they believe in, what they don't believe in, but they are the ones who are in the communities displacing people on behalf of their main contractors. And sometimes you don't know, you can't take them even to court as the way we take government, even when the cases are not heard. So it is extremely very difficult to engage these companies, but we are trying to improve using different mechanisms. You are working with international partners who have expertise on engaging with the Chinese companies. And we are hoping that going forward, maybe we will improve and be able to ensure that we can have effective strategies to engage those companies.
Thank you so much, Dickens. I think this also highlights that, you know, even in terms of companies and an equal level playing field, that without a mechanism that's governing across the supply chain, that even in terms of creating a level playing field for companies, that this cannot be achieved. And then one last question, Dickens, before we move over to Juliette. and also similar to Kete's question is, how have human rights defenders, what has been the experience of human rights defenders in Uganda, especially in the context of, you know, this conflicting, or rather a conundrum between, you know, development and also ensuring that there is a just transition, and especially in the context of climate change. So can you just elaborate on this, you know, on how human rights defenders and the experience has been in Uganda?
Yeah, thank you very much. I think the experience of human rights defenders in Uganda, I must tell you, it is very, very, it is hard even to describe it, because a few years back, we were very, very strong individuals, organizations that would fight for communities up to the end, and they would work together, they would speak publicly, they would do many things together. But for the last like 5-6 years, you have organizations, you have individuals that they will arrest you, they will harass anyone who speaks, they will intimidate you, they will arrest you, they will put you in cells, and afterwards they release you. Whether you file a case for illegal imprisonment, the case will never be heard. So sometimes you just remain there, they release you on police bond, you stay on police bond. Personally, and with 6 of my staff, since 2021 October, we've been on police bond up to now. And then they register your organization, they will blacklist it, they will ensure they go to where you work in the communities. For example, those communities that are suffering illegal evictions, human rights violations, they will go there and tell the local government leaders, don't allow these organizations and individuals to come here. So it is a very, very challenging. Despite all these challenges, I still must say there are many organizations and many individuals in Uganda that they are still fighting. They are still insisting that, you know, those who cannot have voices to speak for themselves need to get someone to speak on their behalf. At least we still engage. And I tell you, even the Total and many other companies, even the government, they still know there are still many human rights defenders here in Uganda and outside Uganda who are working hard, who are putting them on pressure to ensure that human rights, environmental rights are respected. I'm happy that, you know, we use different strategies, working with international organizations like Friends of the Earth France. Without these organizations, it would be extremely hard for us to actually operate here in Uganda. But because our government knows that, you know, they need to get money from Europe, from USA, they somehow listen to international organizations. We work with the international media, that the things that cannot be aired here in Uganda, the international media is able to air it. The international organizations and media, they put pressure on companies, in other words, from their home governments. So companies like Total, sometimes they are forced to actually also say they don't respect, they don't allow disrespect of human rights. They don't allow disrespect of communities. So somehow the government listens to international pressure than the national pressure. So we use different strategies to make sure that we continue working amid these challenging conditions. But I tell you, every attack on one or two human rights defenders sends a very big chilling effect on many of the other human rights defenders. And that's why many of the organizations in Uganda right now, it is extremely hard for them to speak publicly. When you meet one-on-one, they are telling you where we are going as a country, these communities that are suffering, these companies that are causing these problems, they are not happy at all, but they are not willing to speak on record, speak publicly because of the fear of the attacks from the government. Right now, as I told you, Juliette knows that, you know, this ruling that was made just about 2 days ago, we are now thinking about appealing against this ruling. We know we have other appeals which have not been fixed, but it is better than just doing nothing. But I'm very sure if we ask NGOs come and we work with these communities to appeal against this ruling. Many of them will not accept, not because they don't see that there is a good case, but because of the fear of the implications if they appeal against the government. And I must also emphasize that the communities that have been refusing and resisting an fair compensation, they are the same communities, the same community leaders who have been working with us to help us take messages to the communities, because we can't reach everywhere. So when government comes with a strategy and compels them to evict them without compensation, the impact is not only on those 42 affected people, the impact is on the wider communities, because they see the leaders who they thought would actually fight and get justice have been completely focused into the corner. The NGOs that have been working with the leaders have also failed to stand against this injustice. So the impact is very huge. And sometimes, you know, you ask, what next do you do? You are going to file this appeal, it will never be fixed. You are going to tell some of these NGOs, let's appeal. They are not even willing to be on record that they are appealing. These community leaders have been completely broken. So it is a challenge, but at the same time, we have no any other option. We have to continue fighting, and I believe continue mobilizing in and outside the country, we shall finally really succeed. I don't think like there is a way evil can be maintained forever. Time comes when even those who are pushing for, like, profiting from evil, will actually also say, I think we are tired, we cannot continue with this evil. So we have to continue the fight and the struggle. Thank you
so much. Thank you so much, Dickens, for once again highlighting the importance of international solidarity when it comes to, you know, the fight against human and environmental rights. Thank you so much, Dickens. I'll now move over to Juliette. Juliette, are you with us? Welcome. I mean, Juliette, Total Energies is headquartered in France, as we've heard from Dickens. And you know, what has been the experience of cases that have been brought, you know, from Mozambique and Uganda, and what have the challenges been as well in accessing remedy for affected communities under the French law Duty of Vigilance Act?
So hello everyone, good morning. Thank you for the invitation. So first of all, for you to know, for many years, what we've been doing at Friends of the Earth France is mainly campaigning against French companies, being oil, gas, and other companies, mining companies also, and also the banks who finance them, to support the struggles of local communities or organizations that are in different countries around the world. We were campaigning because it was the only tool that we had to try to put pressure on these actors in France. And through campaigning, we had some victories. But anyway, it was always like case by case. And so in parallel, we have always been working also in advocacy for the adoption of binding regulation, binding rules for transnational cooperation to both at the national, EU and UN level, international level. It's very important for us. We think that these different level of regulation, of legislation are very important and complementary. And so we need to fight for them in parallel. So in 2017, after several years of legislative battle, the French law on duty of vigilance was adopted. This is a pioneering law in the sense that it recognized the legal responsibility, liability of parent companies or outsourcing companies over the activities of their subsidiaries, but also of their main subcontractors and providers. So this law help us like make the link between the economic reality of the transnational corporation, which is like it's one big company and that is having the profits through their activities worldwide, and taking all the profit that is made by their subsidiary, or thanks to the outsourcing of part of their activities to subcontractors of providers. And so it's linking this economic reality with now legal reality, that is the fact that they have to be responsible for identifying and preventing human rights violation and environmental risk that can be caused by their activities, and again the activity of their whole supply chain. So this law was adopted in 2017, and only in 2019 the law opened the way for court cases. And so, as Dickens explained, we filed the very first case using this law, which is the case against Total for its Tilenga and ECOP project in Uganda and Tanzania. And at the time, we tried to file a case under summary proceedings, because we were hoping to have, which is like a quicker, was supposed to be a quick legal process in case when there is an emergency to act and to have a court order to prevent a violation from occurring, which was the case in Uganda, because we were quite at the start of the eviction process. There were already a few thousand people that were being evicted, but we wanted to prevent the violation that we witnessed in the first zone of the eviction, which is around the oil plants, the CPF that is being built by Total for its Tilenga extraction project. And we wanted to prevent this violation for escalating to the whole project, Tilenga, and also ECOP, both in Uganda and Tanzania. Unfortunately, it was the very first case, and of course we are against the biggest company in France. They started to question all the different things that they could question in terms of procedure. So we lost 2 years just up to the Supreme Court for the Supreme Court to recognize that we were in the right court, that it was right for us to file the case before a civil court and not a commercial court, which was what Total wanted, because of course we are speaking of human rights and environmental damages, and not about commercial issues. And then there was 1 more year on other procedural issues, and so unfortunately, as Dickens explained, the case was dismissed even before for some a bit complex procedural question, even before the merits of the case, the content of the case itself was never ruled on. So the judge never said, and that's very important to remind, because Total is trying to say the opposite, but the judge have never said whether Total is respecting or not the duty of vigilance law. So what we decided then is not to of course, abandon the fight, and so we filed another case together this time, so still with Afigo, another organization in Uganda, with Survie in France, but this time with directly affected communities, very courageous members of affected community, 26 people that are directly plaintiff in the case. And so this case is just starting. It will be a very, very long case, because even in France, the judicial delays are a challenge. But this time is a case, what's called an action for damages. So that what we are calling is for the court to condemn, to recognize that Total was is liable for the violation of human rights that have occurred in the past years, mainly around the eviction process, but also the response, and this is quite important also, the responsibility of Total in the harassment and intimidation that the communities or organizations like Afigo or Tasha are are suffering because of their mobilization to defend their rights, to defend communities' rights. And so even if, for instance, it's the Ugandan police who is arresting some people, or if it's the Ugandan authorities that are threatening some people in the community or in the organization, there is a responsibility for Total, because they have this duty of vigilance, the duty to prevent the violation linked to their activities. And so in that aspect, this intimidation and this harassment is directly linked to Total's project, because when people are arrested, they are asked about their mobilization against the project. And this has also been recognized by UN rapporteurs that have, in I think 4 or 5 times now in just 2 years, have sent communication to both to Total, but also the Ugandan government and the French government concerning this situation. So now on this case, as I say, legally, we are just starting. We are waiting for the court to put like the different dates for the process. Next year, it will be mainly procedural issues. And so we hope that in 2025, we will touch upon more the content issues.
Thank you, Juliette, for giving us insight into those 2 cases. Can you also elaborate on the disconnect between corporate communications and the reality of the implementation of human and environmental standards? And I mean, this is especially as it relates to the communication about oil and gas projects, you know, as it relates to also consultation within these projects and stakeholder engagement in the context of climate change, where it is very difficult, or becoming difficult, to justify these new projects.
Yeah, so what we see is that it's important to know that also aside of the court case, we are also involved in campaigning activities, because we think that both need to go together to bring attention to the court case, and also we have all this long judicial process, we need to keep under pressure while waiting for the ruling. So what we see is that, and it's also all the work that we are doing within the International Stop ECOP Coalition, we have managed to, and this is the word of a Total CEO, to transform ECOP in like an emblematic case, the symbol of the anti-oil fight. And so ECOP and the Stop ECOP mobilization has become a bit a nightmare for Total. But what they have done is responding by communication. So, for instance, they have been organizing press trips a lot in Uganda and now in Tanzania also. We know also that they are preparing one for Mozambique later this month, to try to change their image in the press, to counter our investigation, our campaigns, etc. And they are also trying to show that they will have like a positive impact, a net positive impact on biodiversity. And more globally, they are also trying to paint them as a company that is engaged in energy transition. And so on this, we have also filed a case against Total, another case against Total in France, together with Greenpeace France and another organization called Notre Affaire à tous. And this is directly a case against their greenwashing. It's a case for unlawful commercial practice. So concretely, we are suing Total over all the communication that they have done 2 years ago when they changed their name from Total to Total Energy, and trying to make people think that, that they are engaged in energy transition. So you will see that all their communication is about renewable energy, solar, wind, etc. While the reality is that most of their activity is still 80% or 90% fossil fuels. The other thing that we are attacking through this lawsuit is all their communication about gas being a transition fuel, being a clean energy. And so we are also challenging that, as gas is also a fossil fuel. And so in that, we are showing the discrepancy between what they are saying and what they are trying to do. And this is really important because it's not only misleading people, like consumers in France that may go to Total oil station, etc. But it's also misleading policy decision makers. What they are trying to do is all their communication, and we've shown also that they always have like big communications, for instance, in international airports, but mainly of G20 countries, because they are trying to influence political leaders, not to push them, not to regulate them. You know, it's the message mainly from Total is doing, well, I'm already engaged in energy transition, so you don't need to impose any rule on me. And so this is kind of working on some policy and decision makers. And so what we are doing is also denouncing this use of communication as a tool of lobbying.
And thank you, Juliette, for highlighting the greenwashing that's being done by companies through their corporate communications. And just to briefly also touch on our final question before I hand over to Erika, is can you elaborate on the relationship between Total Energies and the state of France, and how this has played out in Mozambique as well?
So yeah, so Total is a private company, but in the past it used to be partly state-owned. And so there are very, very strong links between Total and the French state, and especially for activities of Total in Africa. It was before more in former French colonies, but in reality we see that it's like a whole area of influence, and now also in English-speaking countries. And so what we have done two investigations that we have released, one on Mozambique and one on Uganda. We show first all what we call the revolving doors. So the fact that there are people from Total and from the French government that are going back and forth. So Total hiring people from the government, or putting some of these people directly, like as Macron's advisor, or as people keyed in the Ministry of Foreign Affairs or Ministry of Defense. And so this giving them like direct access to the decisions that are made. And also for the people that they hire, they also gave them like all the contacts and all the knowledge of how things work in the government. And so we see, for instance, in the case of Uganda, that the French embassy is really like very key to help Total to support, also giving their good image through the sponsoring of Total of their activities, etc. But we also show that both in the case of Mozambique and Uganda, there is also a whole military cooperation of France. So for instance, so France is saying that in the case of Mozambique, they are just helping the fight against terrorism. But why are they doing there in Mozambique? It's because there is this big project from Total. And the same in Uganda, you have like the French army that has trained Ugandan soldiers that are now the one that are like putting pressure and harassing people that are mobilized against ECOP.
Thank you very much, Juliette, for highlighting also the complicity, I guess, of states and in other jurisdictions in these human and environmental rights violations. I'll hand over to Erika now. Erika, welcome. Thank you so much for joining us. Erika, I just want you now let's go into a discussion about, now closing or addressing these international gaps that linger in the transnational governance of extractive supply chains. And we have the United Nations negotiations at the moment to elaborate on a binding treaty on business and human rights to regulate transnational companies. And as a first question, I would like you to highlight the limitations of non-binding standards in the form of the United Nations guiding principles, and how this has played out in Mozambique when it comes to the protection of human rights against corporate violations.
Thank you very much, Sikho. So I think there is a lot of documentation and studies showing corporate power and corporate impunity, special transnational corporations' power and impunity in countries like Mozambique, but in general in countries of the global south. So I think it's important to note that there have been quite a few attempts to regulate transnational corporations on issues related to human rights, I would say for the past 4 or 5 decades. And all these previous initiatives, they ended up being weakened into voluntary standards and guidelines, such as the United Nations Guiding Principles. Even due diligence legislation that is coming up in different countries and regions is in a way a watered down version of the kind of legislation that social movements and organizations have been advocating for. So as Juliette was saying, we have been demanding strong and effective binding rules for transnational corporations at the different levels. So not only national level, but also regional and international, which is really important. So the non-binding standards and mechanisms, they've been proven largely insufficient and inefficient when dealing with corporate crimes and violations of human rights linked to transnational corporations' activities. So the UNGPs and other mechanisms, they rely a lot on self-regulation, and they don't really have the power to ensure compliance or to sanction violators. We have been witnessing this. There are a lot of companies that are in principle, they adhere to UNGPs and voluntary mechanisms, but in practice, they are still violating human rights and destroying the environment almost total impunity. So one thing is that the logic of these voluntary standards is that they rely on the fact that transnational corporations don't really know what's happening across their global value chains. So we saw actually that that's not true, you know, when these issues are denounced and when people are fighting against these projects, companies like Total, rather than addressing the issues, they actually invest in public relations and propaganda and making sure that the public thinks that they are a responsible company. Even here in Mozambique, some government officials have referred to Total as the company that has even rebranded itself to show how committed they are to the transition. So basically changing your name serves to send the idea that you are responsible. So this is not enough. And of course, we've been defending that the global problem of corporate impunity really needs to be addressed by binding legislation at international level.
Thank you, Erika. I mean, we see at least in some global South states and even global North states that trade agreements are becoming more of a barrier in the energy transition, in terms of states being vulnerable to being sued in the international dispute mechanism process. And in the case of a business and human rights treaty, how would this benefit Mozambique as it relates to trade agreements?
So we do understand, and we have been demanding that the UN binding treaty on transnational corporations and human rights must
Queremos que o nosso compromisso tem de ser reafirmado, particularmente no comércio. Então, existe uma superioridade hierárquica, mas os direitos humanos têm de prevalecer. Isso é muito importante. Nós vemos como os direitos humanos são violados. Existem cláusulas muito perigosas que fazem parte de acordos de investimento, como as SDS. Elas permitem que corporações processem estados e tenham compensações milionárias. Esses instrumentos são usados como ferramentas pelas companhias, particularmente companhias que trabalham com combustíveis fósseis. Eles usam essas ferramentas para impedir que os estados produzam uma legislação na área da saúde ambiental. Moçambique é o país que tem o maior potencial de responsabilização do SDS. Então, em Moçambique temos contratos com companhias de gás e petróleo. Existe o risco de perdas na casa dos 15 bilhões de dólares. Isso significa que as mãos do governo de Moçambique estão atadas. Eles podem ser processados na casa dos bilhões de dólares. Caso o nosso governo decida trazer nova legislação para reduzir o número de projetos de combustíveis fósseis. Daí essas companhias como Total e outras vêm como esse governo que põe o governo numa posição de necessidade de se proteger. Daí a importância desses princípios de legislação vinculativa da ONU sejam respeitados. Muito obrigada, Erika, por destacar isto. Né? Esse tratado vinculativo vem diminuir essa lacuna, colocando os direitos humanos acima das prioridades de comércio, se é que eu posso descrever isso assim. Erika, mais uma pergunta. Como é que um tratado vinculativo lida com os defensores dos direitos humanos? Nós vemos exigindo, enquanto sociedades e organizações que defendem os direitos humanos, nós exigimos que as vozes daqueles que lutam contra as corporações estejam no centro das negociações. É claro que estamos falando sobre agricultores, pessoas simples, pescadores, indígenas, mulheres. O tratado deve colocar o seu foco na sua proteção dos ativistas, denunciantes, pessoas que estão na ponta. Nós ouvimos a Kete, a Dickens, a Juliette, e ouvimos a importância da defesa desses mecanismos. Esses mecanismos devem garantir a proteção da justiça, o direito a reparações, o direito e até mesmo o direito a informações. Temos de reconhecer uma coisa: a falta de reconhecimento dessas pessoas deixa as pessoas ainda mais vulneráveis. Daí a necessidade de priorizar isso nos tratados. Muito obrigada, Erika. Agora, ouvimos um pouco Dickens e Kete. Algumas coisas se repetem nesses projetos, esta falta da consulta significativa. Você poderia falar sobre como a falta da diligência se mostra nesse tipo de projeto? Na verdade, nós estamos pedindo mais do que consultações, mesmo consultações significativas. Nós temos um direito que é reconhecido, que é o direito que é reconhecido como SFPIC. Nesse caso, as comunidades afetadas devem fazer parte do processo de decisão. Afinal, eles serão afetados. FPIC foi primeiro introduzido na Convenção de ILO, a Organização Internacional do Trabalho. É muito diferente falar entre consultação e FPIC. A consultação significa o seguinte: todos os interessados devem ter a oportunidade de reunir-se e dar as suas opiniões. Basicamente é isso. Né? Existe uma implicação. As decisões são feitas em outro local. Então fica claro que o processo de consultação está aberto e vulnerável à manipulação e abusos. Já o processo de consentimento coloca essas comunidades num local muito diferente no processo de negociação. Significa que não é suficiente informá-los sobre o que vai acontecer, nem ouvir os seus medos ou anseios. Não. Mas de conseguir deles, é o mais importante, não receber o seu consentimento. Isso significa que é reconhecer o direito de não dar o seu consentimento para um projeto qualquer. Então, o direito de dizer não para projetos poderosos ou não desejados nos seus territórios. Eu falei sobre o FPIC, falei sobre o artigo número 6, e ele deve ser reforçado. O objeto principal aqui é legitimar, proteger e promover o direito das comunidades, principalmente comunidades originárias, contra a exploração. Ou seja, o FPIC vai além dos projetos nesse momento, né? As comunidades têm o direito da autodeterminação, de decidir como eles querem se desenvolver. Então, precisamos de um tratado que previna violações e coloque essas comunidades no centro do processo de decisões e desenvolvimento, né? Que eles não possam apenas oferecer as suas opiniões, mas o seu consentimento. Me parece que o escritório de Geneva tem um problema técnico. Então, eu tenho uma pergunta aqui de última hora. Erika, você poderia falar um pouco sobre os nossos desafios? Como, por exemplo, um caso levado de Uganda para a França. Nós ouvimos da Juliette e da Dickens sobre como, às vezes, problemas processuais podem atrasar um caso por anos. Um dos problemas, às vezes, é sobre a jurisdição. Às vezes, um tribunal francês não pode pegar um caso porque ele começou em Uganda. Você poderia falar um pouco sobre como esse assunto pode ser remediado em jurisdições diferentes? Sim, o tratado deve abranger o acesso à justiça. Essa é uma das coisas que nós defendemos. É o princípio de não conveniência. Isso foi eliminado do documento. Então, o tribunal não pode dizer que esse caso não pode ser ouvido. Basicamente, as pessoas afetadas podem escolher a jurisdição mais conveniente para eles. Estamos também advogando a inclusão das necessidades e avaliando as jurisdições possíveis. Isso inclui os tribunais do país de origem do TMC, mas também do país anfitrião, ou mais. Um país aonde esse TMC tem acesso, ou aonde a corte oferece acesso também. Nós abrangemos, então, o acesso à justiça. Mas o que é mais importante é que as pessoas afetadas possam escolher aonde eles vão conseguir acessar a justiça. Então, algumas provisões têm de ser reforçadas e outras inclusas nesse processo. Muito obrigada, Erika. Muito obrigada por essas ideias.
And through an international mechanism that governs supply chains, whether it be textiles, where human rights violations are common, whether it be extractives, whether it be in the agricultural sector, but the gaps are lingering across the supply chain. And also, especially in terms of access to remedy, to just note that some regional mechanisms like the Corporate Sustainability Due Diligence Directive that's currently a draft that aims to regulate within the European Union corporate supply chains, that even sometimes in those binding legislation, that sometimes access to remedy remains an issue as it relates to jurisdiction, for example, and cannot be necessarily fully addressed within the context of a regional mechanism. And with that said, I would like to thank our panelists, Juliette, Dickens, and Kete, who had to leave us because of power issues, and Erika, of course. Thank you so much for providing insight into the different regions, the regulations of supply chains within the EU and within different states, and Erika within a more broader framework in the international level. I would like to now hand over to our Geneva office. They might be having technical issues still, but maybe we give it 2 minutes before they begin. Thank you so much to also everybody who's joined us today. Thank you very much.
Thank you, Sikho.
Thank you. Bye.